So
Good morning.
Good morning, Chidimma. Do you hear me?
Yes, good morning, Mr. Isaiah.
Good morning.
Nice to have you.
So your volume is a bit low from my end. I don't know.
Okay, give me a second.
Ye-
Is it better now?
Yes, much better for me.
Hello?
Yes, it's better. Do you hear me?
Yes, I can hear you.
Okay.
Good morning, Amala.
yes, can you hear me?
Yes, I can. Okay.
Loud and clear, right?
Before the participants come in, I just wanted to do a tech check to make sure everything is in place. So, right. I think a couple of people are already coming in.
Chidimma, can I just check my screen share to ensure that you'll be able to see my screen when I start my slides? Chidimma?
Yes, you can, Mr. Isaiah.
Okay, thanks. So just confirm that you see it.
Yes. Perfect.
Okay, great. So when it's my turn to present, just to save on bandwidth, when I'm sharing my screen, I'll turn off my camera. I hope that's okay, just so I don't have any connectivity issues.
Okay, that's fine, sir.
All right.
Ms. Amala, we can see you. Can you check your screen share to see that it's
Okay.
working?
You can see it, right?
Yes, but if you can make it bigger, it will be better.
Sorry.
Okay, it's for him to change it to.
Is it okay
Better.
now?
Yes, yes. Thank you. So it's 11 o'clock. I hope we can all hear me.
Yes, we can hear you.
Okay, so we're going to start now. We have about 29 participants. Good morning, ladies and gentlemen. I welcome you all to this all-important webinar on intellectual property dispute resolution. This webinar is organized by the Abuja Chamber of Commerce Dispute Resolution Center. My name is Chidimma Onyiaorah, and I'll be your moderator. We already know that the world of intellectual property has been facing a lot of challenges in time past. And even with the emergence of the COVID-19 pandemic, a lot of businesses have occasioned great loss and economic downtime in their businesses. These businesses has been affected and their intangible assets has also been affected. They are now looking for better and affordable ways of resolving such intellectual property disputes. There is an important need to establish an adequate dispute resolution mechanism to resolve these disputes that are arising in the intellectual property world, hence this webinar by the center. This webinar is going to examine the relevant laws regulating intellectual property. It will look at causes of intellectual property disputes and examine different kinds of conflicts that may arise in the intellectual property world. It will also suggest the dispute resolution mechanisms to use in resolving these disputes. We are going to be having two speakers for this webinar. The first speaker is Amala Umeike. Amala is a partner at the Bridgeford Attorneys, who specializes in intellectual property and dispute resolution. He specializes in providing sound legal advice and representation to foreign clients in areas of intellectual property. He's a member of the International Trademark Association, Intellectual Property Law Association of Nigeria, and other relevant associations. Amala is going to be taking us on the first part of this webinar, which would examine the relevant laws relating to intellectual property. Our second speaker is Aisha Bozimo. Mr. Aisha Bozimo is a partner at Bozimo and Company. He has a niche for arbitration and litigation. He's a fellow of the Chartered Institute of Arbitrators and listed on Who is Who Legal as a future leader in arbitration. Isaiah has also represented a lot of high net worth individuals and governments in arbitration. He's a member of the Young SIAC Committee. He previously chaired the advisory board of the Lagos Court of Arbitration Young Arbitrators Forum. Ladies and gentlemen, I would enjoin us to pay rapt attention, mute your microphones, and use the chat button for any comments or questions. Each speaker has 30 minutes to make their presentation and will allow for 15 minutes to participants for discussions and questions. Please welcome Amala to make the first presentation. Thank you.
Thank you very much, Chidimma, for the kind introduction. My name is Amala, and I'm a partner at Bridgeford Attorneys, and I'll be taking us through an introduction on intellectual property generally and what it has to do and the various laws that guide intellectual property in Nigeria, so that we would have a feel of what the subject matter is for some of us who do not understand it. And then my co-panelists will then talk about, drill down on the various disputes that would arise within the intellectual property space and how to resolve those disputes. So I'll be sharing my slide. I hope you can all see my slide.
Yes, Amala.
Can you help me? Okay, all right, thank you. So we've tried to divide discussion into categorization of IP, that's intellectual property, the relevant bodies and the laws that guide it, trademarks, copyright, patents, and then industrial design. Maybe it would be a good starting point for us to look at what intellectual property is actually. And basically, it's just the protection of the creativity of the mind. You know, intellectual property has to do with protecting what the mind has created. It's an intangible asset. So unlike a tangible property that you can hold, it chooses in action. So it's not something you can hold. It protects what the mind has created, so to speak, whether it's by way of inventions, whether it's by way of expression of ideas, whether it's by way of the process of making a particular thing. So that's essentially what intellectual property is and what it has to do with to protect. You might want to divide IP into two broad categories. One has to do with industrial property, and under it you have trademarks, patents, industrial design, trade secrets, and geographical indications. These are all the categorization of IP that has to do with commerce, so to speak. And then you have copyright and related rights. These have to do with the protection of literary works. I will still drill down on copyright, artistic work, musical work, essentially an expression of an idea. Without much ado, let me go to what are the relevant bodies and laws. And in the course of the discussion, you'll find that we would touch on most of these laws. In Nigeria, basically, within the intellectual property space, we don't have, unlike some other jurisdictions, we don't have intellectual property law. So what we have is that different categorization, we typically have a particular law guiding it. There are propositions before the National Assembly presently. We have a standalone or an all-encompassing. So you have the Copyright Act, which is the law that governs related to copyright. You have the Trademark Act, very Patents and Design Act, and then these are the principal IP. Maybe a bit of context as to why we don't have laws. For lawyers, you know that National Assembly of laws that laws are enacted by 2007. Intellectual property is not exclusive. So it's not an incorporate Now, however, some laws sorry, I think okay. So laws that not deal directly with intellectual property, but have one or two relevant one the protection of one's IP right, the protection of one's intellectual property right. And these have to do with an allied matter that CAMA. The good news is that under the new CAMA, there are certain provisions that have, so to speak, brought some level of development within the IP space. So for instance, under the new CAMA, you find that you can now use IP assets as security. That's something we didn't have under the old CAMA. So for presently now, which is good news for practitioners and people within the creativity space, that not just bringing in physical assets as securities in order to obtain credit. You can also, when you are talking to your bank, my co-panelists will talk about IP assets and the relevancy, so I don't want to go there, but you find out that you can use the immense value that is incorporated within your IP asset to get credit from whether it's a bank or from a lender. So CAMA now recognizes it. And one very important development within CAMA is the recognition of something that we've been advocating for quite a long time, and that's company names that use the trademarks of mostly foreign brands or well-known brands to incorporate companies in Nigeria. There are now extant provisions in CAMA that deal with that and the procedure that you would follow as a brand in order to be able to expunge or deregister a company that has used your trademark. Under the old CAMA, there was a cumbersome process that involved going to court, but now there is, so to speak, a less cumbersome method of dealing with that. Also, you have NOTAP, you have SON, you have the FCCPC Act, you have NAFDAC Act, you have NIFTA. All these things are laws that have been listed here, including the EFCC Act. Most people do not know that the EFCC Act makes provision empowering the Economic and Financial Crimes Commission to look into crimes relating to intellectual property. It's there. So these are laws that have to do with intellectual property. Then you have bodies that, and they
I'm sorry, Amala, so sorry to cut you. Some people can't hear you. Could you be louder?
Can you hear me now? Is it better?
I think so, yeah.
Okay. So, so when you look at bodies, you look at the Nigerian Copyright Commission, the Trademarks Registry, the Patent and Designs Registry, the Corporate Affairs Commission. So all these bodies are bodies both on the local and international level that has to do with intellectual property. Because of time, I won't want to drill down on that. So let's just look at the nitty-gritties of intellectual property and the rights that accrue thereto. And one of them is trademarks. It's really important. I think that's probably the most important, most popular right everybody probably knows, trademarks. And what does trademark actually do? Trademark protects device, brands, names, signature, anything that indicates the source of origin or the end person or the person, the proprietor of a particular product. So to practicalize it, it's anything that would be able to let a consumer know that this particular product is coming from a particular manufacturer or a particular producer or a particular person would be trademarked, right? So any sign, any design, any name, any number, any combination, any word that's able to tell a consumer that this particular product is coming from this particular person would be a trademark. So when you look at a phone and then you want to know where this phone, who manufactured it, or who is the person who owns that particular right in that particular phone, you will find the name of the manufacturer there on that particular phone, whether it's Apple, whether it's Samsung. That particular thing that allows you to know the person that manufactured that product or the source of origin of that particular product, it's a trademark. And in Nigeria, what trademark does is that it's when you've registered it, which is the easier route, it allows you to have exclusive rights, or so to speak, monopoly over that particular goods or services that you've registered it in that class. So one of the things is that when you want to register a trademark, so when you want to register, for instance, let's say Amala, Amala U for as a trademark, right? And you want to register it for clothes. You want to start selling clothes, and then you make your clothes, you brand it Amala U, right? So whenever you register that trademark, what the law says is that you own the exclusive right, you own the monopoly to use that trademark which you've registered to market that particular product. And nobody else can actually use that product, because it's really important to the law and to the society that people are able to connect the name of that particular product to the source of origin. because that is a way of stamping genuity. That is a way of stamping correctness. That's also a way of saying that this particular product came from the right source. So that's why the law is particular about that. Although one can say that even if you don't register your trademark because of the common law thought of passing off, you can still be protected. But I tell you, that's quite true. But from a practical point of view, it's easier for you to register your trademark than for you to leave it to the thought of passing off, because it's a much more cumbersome way of protecting your rights, and it's less cumbersome if you've registered your trademark. So what the law on trademark does is that it allows a person, a proprietor who has registered his trademark, to own the right to that particular trademark, so to speak, in perpetuity, insofar as you are renewing that trademark. So initially, after you've registered, on application, so not just the date you've registered, on the date of that application, once you've registered it, the law protects you for an initial period of 7 years, and then you can continue renewing it in perpetuity every 14 years. And like I said, you find that you register trademarks in particular classes. So you don't just, if you register a trademark, you are not registering it for all goods and services. You are registering it in respect of a particular goods and services. And in Nigeria, they've been divided into 45 classes. It's the NIST classification. So when you are registering a particular trademark, it has to do with a particular goods. So if you are registering a medical product, for instance, and you want to register a trademark in that regard, you register it in class 5 that has to do with medical products. If you're registering milk products, for instance, you register in class 29. If you are registering alcoholic drinks, for instance, you are registering it in class 33, and so on. So the idea is that you talk to a good IP lawyer when you want to register a trademark, who would be able to match the goods and services which you are going to trade, or you're going to commercialize with that particular class. So we've also given a rundown of the practical way of when you want to register a trademark, how that works. So essentially, what you do is to file your application. Before you file your application, you can do an availability search just to know whether that particular trademark is available, or whether somebody else have already registered it. So, like I said, if you remember, once you register your trademark, you would have monopoly over the entirety of that particular trademark. But one thing which I didn't say is that it's not just in respect of that particular trademark, but also it has to do with similar trademarks. So if you register, for instance, Amala as a trademark, and then another person wants to register Amala, just has a hyphenated way of writing it, you'll find out that it's similar, and the law will not allow that person to register the trademark. So when you do an availability search, if the mark is available, you proceed to apply for it, and the trademark registry will examine it, and after examining it, they will then decide whether it's accepted or not, and then it will be published in the journal. If somebody wants to post it, they'll post it within a 2 months window, and after the 2 months window, it will then proceed to registration. Now, one important point is that one has to use your trademark. So you don't just register your trademark and then you leave it there. You have to use it, and if you don't use it, it will become vulnerable to cancellation actions. Now, this is a place that is quite important for commercial persons, and that has to do with assignment, licensing, and transfer of trademarks. And that's where you see a lot of the disputes. So because it's a property, you can, even though it's intangible, you can transfer it to another person as if you're transferring a real property. You can transfer it by way of an assignment or license. So if you are a foreign brand, for instance, and you don't want to trade directly in Nigeria, you can have a local distributor. And that is why it's important for you to register a trademark in Nigeria, even if you're a foreign brand, because when you then do that, you then license that trademark to your distributor. So if tomorrow you have a problem with your distributor and you want to change it, then you can simply revoke that license and give it to another person. So that's actually the tool that's used to trade, because without that trademark, then you will not be able to continue the sale of that product, even if you are an international brand. Even as a local brand, you can decide to license it to someone else, another distributor, to help you market, maybe someone that has the requisite marketing experience in the market. So you can assign it or you can license it, and when you do that, it's not that you are required, but it's optimal for you to record it at the registry so that you then have a certificate proving that. So that would be that for trademarks. Sorry, I'm trying to rush because of time. So for trade secrets are those information that are generally not available to the public, right? They are usually those things that are not known within the business circle and that have some form of benefit, economic benefit to the person who holds that secret. And then also, you find out that that person who holds that secret have expended reasonable efforts in order to maintain that secrecy. So a perfect example is Coca-Cola. So most companies, and that goes to some of the tech startups, right? You find out that there is probably a formula for your short code or the way that you are writing your code, or like the example we gave you, Coca-Cola, the formula for the Coca-Cola drink, right? It's a secret. Nobody knows it. I understand it's in a vault, right? It's guarded as a secret. It can even be a business. Your marketing strategy, the way you market, the way you sell your products, your style, can be a secret which you don't want to give out to your competitor. So that's what's actually called trade secrets. In Nigeria, there is no specific law for protecting trade secrets. So what actually happens, especially for companies and their employees, because their employees will get to know the secret, is that they sign a non-disclosure agreement, with them. Sometimes you put it in a clause in your employment agreement, that says that, for instance, somebody cannot work for another company because you don't want that person to divulge the secret. Under the new FCCPA, you find out that there is a provision actually allowing that, but it says that that restraint of trade must not pass 2 years, must not be more than 2 years. So, so usually you protect it through the relevant unfair competition laws, and also you can protect it by way of an NDA that says that somebody cannot divulge a particular secret to a competitor or use that secret for his own personal benefit. So you go to copyright, and copyright is essentially an exclusive right that is granted to a right holder for a limited number of years, and it has to do with the protection of the expression of ideas. So if you look at it, I said expression of ideas and not the idea itself, because if you just sit down in your house and you are thinking about something, and then somebody then probably has similar thoughts and then goes out and manifests that thought, there's no way of protecting your own thought because you have not manifested it, and you cannot, for instance, take an action and expect the law to protect you. So what copyright does is to protect the expression of an idea. So for instance, if you have a work, a literary work, and you have penned it down, and it's your idea, you've penned it down, you've not published it, but you gave it someone to read. The mere fact that you have already penned down your idea should be protected by law, and that is what copyright does. So what copyright, the law does, is to protect literary works, musical works, artistic works, any work that has to do with one's expression of his ideas. And in Nigeria, you don't actually register unlike where I said you register your trademark, you don't register copyright, actually. So once that idea has been expressed, you find out that it's protected by law automatically. It's automatic. It doesn't need you to register it. What happens is that we have a copyright commission, and then you, so to speak, notify them just for proper record keeping sake. So what we typically advise people to do is to have a record of that expression of your idea, so that tomorrow you'll be able to say that this is actually the date when I expressed this idea. This is the date I came about this particular idea, and I should be actually conferred with this particular right. Recently, there has been some disputes, I think, between a gospel musician and a particular musician. I think the matter is in court, although maybe my co-panelists may mention it, but it's sub judice. But these are examples of some of the disputes that usually come out from copyright, and you want to protect your expression of ideas, and you want to keep records of those ideas for tomorrow's sake. So like I said, it's not a right that lasts in perpetuity, unlike trademarks. Once you are renewing it, it will last in perpetuity. So we have broken down, some are 70 years, some are 50 years, and at the end of that, the work goes out to public and everybody can use it. I'll quickly rush this and go back to patents. And patent has to do with the rights that are granted by the government to protect inventions, or inventions that are new, or something that has become new, a way of doing something that has become new, and that involves an inventive step, and it can be applied for an industrial use. So that has to do with patent. There's a Patent and Designs Act in Nigeria. The only problem we have in Nigeria is that we don't have a proper examination system in Nigeria. So what you do is to deposit at the registry. They don't examine it as to content, unlike what you do at the trademarks. So I would then rush over to designs, and industrial designs essentially has to do with the combination of lines and colors and any three-dimensional form. And so what the law does is to protect designs or combination of colors, and allows you to register it and own exclusive rights in that regard. I realize my time is up, so I'll probably not spend further time on this, and then allow my co-panelists to take off from there. Thank you very much.
Okay. Thank you so much, Amala, for this wonderful presentation on IP rights and the relevant laws guiding it in Nigeria. We will then invite Mr. Isaiah Bozimo to take the second part of the presentation.
Chidimma, thank you very much indeed. I hope everybody can hear me clearly. Thank you also to the Abuja Chamber of Commerce primarily for organizing this very important webinar. And secondly, for inviting Amala and I to come and share some of our thoughts regarding the IP industry as a whole, and specifically resolving disputes that arise in intellectual property transactions. So Amala has given a very broad overview as to what the different intellectual property protections are. So my presentation will cover three broad areas, okay? So primarily, I'll give an overview of the various dispute resolution mechanisms that are available for the resolution of IP disputes. Then I'll go on to talk about the key features of each one and highlight what the relative pros and cons are. So in doing so, I'm going to turn off my camera. I hope you don't mind. I'm doing so to save on bandwidth and to ensure that the presentation is as seamless as possible. And also, I like to always engage with everybody in the audience. So from time to time, I'll be coming to you just to get your thoughts on one or two issues. And I'd be really grateful if you can just let me know what you're thinking by dropping a comment in the chat to the questions I asked. So, so while Amala was making his presentation, what struck me was the extent to which the IP industry is regulated. And I was wondering, why is it so? Why has the law gone to such extent to protect intellectual property rights? So now let me come to you first. Now, what you're going to see in your screen are a series of companies, right? And just in the chat, can anybody sort of hazard a guess as to what this group of companies represents? And what is sort of the common denominator between them? So primarily, just have a quick go. Type it in the chat. This group of 10 companies here, what do you think they represent? And what is the common denominator between them? So while you're having to think about that, so this group of companies actually represents the 10, Max, thank you very much. These are the world's most valuable brands, exactly. And Bassi also says these are digital companies. You're both correct. So to a great extent, they do have digital components to them, but they're not all digital companies, all right? But these are the world's top 10 most valuable companies. And with the exception of perhaps Saudi Aramco, all of them are tech companies, right? Or all of them have, to a large extent, some technological element to them. So this tells us the economic value of intellectual property. It is a central component of the global economy, and specifically the global knowledge economy. So if you think about it, the effective use and exploitation of those IP rights is critical to the success of the business. So for instance, Amala mentioned distribution agreements, licensing agreements. All these various components are critical to the efficient operation of the global economy. So when you have something like a dispute, it will interfere with those IP rights. In other words, it makes the operation not as efficient as it ought to be, and even risks sterilizing the use of an asset that lies at the heart of a commercial arrangement. So for instance, if the parties have a dispute and one says, for the duration of this dispute, I will restrain you from using this IP right, then we'll see that it has a profound effect on not only on the operation of that commercial arrangement between the parties, but sometimes even to the existence of a particular brand or a particular company. So it is critical that the parties are able to manage and resolve their IP disputes efficiently. And in order to do so, they must be familiar with the dispute resolution options that are available to them. So let's take a look at what those options are. And you'll find that they fall within sort of two broad categories, right? First of all, you have non-binding dispute resolution processes. Then you have binding dispute resolution processes. And in each of those, you will find that it could involve the intervention of a third party, or it could be between the parties themselves. So at one end of the spectrum, you have a non-binding process without a third party intervention, which is negotiation. Then you start to go across the spectrum. You have the involvement of third parties. So you have processes like mediation, conciliation, mini trial, early neutral evaluation. And then you go to the other end of the spectrum where the party control is diminishing more, and you are ceding control now to a third party. So these are more formal and structured processes. Again, you have ENE, that's early neutral evaluation, but this one is the binding element of it, expert determination, arbitration, and litigation. And we'll go on, like I said, to have a look at the specifics of each one and why they may be suitable or unsuitable for determining IP disputes. But where I think is also important to look at is when the IP disputes arise, right? What do the parties consider as priority when they make their dispute resolution choices? What drives their decision to resolve their dispute in any particular forum? Well, let's look at the top three, right? So in international contracts, the top three determinants are costs, time, and enforceability. Enforceability is key in international transactions because, as you can imagine, the parties will be involved in different jurisdictions. Okay, so if, for instance, I obtain a judgment in country A, then I'm already thinking of how am I going to enforce that court judgment in country B. So they're looking for a seamless enforcement process in addition to a process that is time and cost efficient. Now, for domestic contracts, the top two determinants are the same, cost and time, but they're also looking for a quality outcome. So they're looking for an outcome that represents value to them, that represents the correct decision, correct in air quotes, and one that they are going to be able to accept. Okay, so let's sort of summarize this and look at it individually in individual chunks. So the first determinant, costs. IP litigation is extremely expensive in terms of duration, in terms, not only in terms of monetary terms and in terms of instituting the process, but in terms of the possibility of having your intellectual property right out of commission. That will harm your business exponentially. So what that calls for is a suitable and appropriate solution for your IP dispute. So depending on the type of dispute you have, it may be more appropriate to resolve it through negotiation than litigation. But conversely, where you see from the nature of your dispute that it's mainly legal points at issue, then maybe negotiation is not the appropriate forum. So these are the things you're looking at. Okay, so the next thing you want to look at is the expertise of the neutral that is determining your dispute. Because IP, by its very nature, is very specialized and very technical. Okay, so we want neutrals who understand the industry and who will be able to apply their expertise in resolving our disputes. And if they do so, we are satisfied with the quality of the outcome and we will more readily accept it. Okay. Then another consideration you need to look at is the very short product and market cycles in intellectual property. So I think Amala gave the example of, for instance, phone brands, right? These very big technological giants in the phone industry, and they will come up typically with a new model of a phone each year. So that phone has a very short product cycle, as you can imagine. Now, if there's a dispute that affects the launch of that product, then you're essentially out of the market for one product cycle. So we need a time-efficient procedure, all right? So the next one is the confidential nature of IP. Again, Amala made reference to trade secrets. He made reference to the secret formula for Coca-Cola. Now imagine there is a dispute that concerns that trade secret. And if you file a court action, that formula is now a matter for public record. Okay, so the parties may want a procedure that is private and confidential in nature in order to keep that trade secret protected. And again, you have to consider the collaborative nature of IP. A lot of these relationships involve more than one commercial party. So again, I'll take the tech industry, for instance. If you look at the supply chain, then you will see how many licensing agreements are in place, how many distribution agreements are in place. And because of how collaborative this industry is, then you might need a mechanism that will preserve the parties' long-term relationship. Okay, so these are the several factors that the parties will consider in determining what dispute resolution procedure is most appropriate for them. And before I proceed, I would just ask as a courtesy to the other listeners, if you would please all ensure that your microphones are muted so everybody can hear clearly. All right, so with that, let's now take a look at some of these dispute resolution mechanisms and their relative pros and cons. Because if you recall, I'm saying that in order to determine which one is most appropriate you first need to understand what is the nature of my dispute. What do I want from this dispute? Do I want a more time efficient process? Do I want to control the proceedings more? Is the dispute such that the parties cannot do it on their own and they require third party intervention? So all these factors will now determine which type of dispute resolution process you will engage. So the first is the most flexible, negotiation. And as we all know, it involves the parties themselves attempting to reach an agreement on the matters in dispute between them and without the assistance of the third parties. And any discussion that takes place between the parties is done on a without prejudice basis. And what that means for the benefit of non-lawyers is that anything we say on the negotiation table as a general rule is not admissible in any subsequent court or arbitration proceedings. So if I make a concession in the negotiation and negotiation fails, then you can't take that as my admission of wrongdoing, for instance. So that keeps the parties open to discussing ways to successfully settle, okay? So what are the advantages? Well, there are obvious time and cost savings. It's very flexible, and the parties retain full control over the discussions. Cost savings in the sense that you don't have to involve lawyers. You don't have to involve lawyers, and you don't have to engage a formal dispute resolution process. And you can set a time limit to it. Okay, so you can say, let's negotiate for time X and see how we can maintain our commercial relationship. Like I said, any settlement reached remains confidential and is made without prejudice. So you don't have, if you have a settlement, you don't have to go through the subsequent procedure of having to enforce it in the court and then having the terms of those settlement become public. If you want to keep it private, negotiation might be one for you to consider. Well, what about the negatives? So negotiations can be such that the parties become deadlocked and they simply cannot make progress. They are so entrenched in their respective positions that none of them wants to yield. Okay. Likewise, you may have a weaker party that feels disadvantaged because they just don't have equality of arms between a much stronger party. So there's a perception that they will be overwhelmed in the negotiation process if a third party doesn't intervene, a neutral third party that will look at the issues objectively and will try to take the considerations of both parties when making their decision. And likewise, you might have a dispute that is so technical that negotiation simply is not suitable because it might require mechanisms that need a neutral third party, or that might compel one of the parties to, for instance, make documents available. So these are the general advantages and disadvantages of negotiation. So if we move on to mediation, mediation is essentially a facilitated negotiation. What that means is that a third party will now intervene, and that third party will try to identify the issues in dispute and explore the options for settlement between the parties. And there are two general types of mediation. The most common in Nigeria is called the facilitative mediation. And what the mediator will try and do there is to facilitate the parties' agreement. So the mediator will not propose a settlement for the parties, but will simply enable discussions to flow between parties A and B in the hope that they will narrow the issues and they will be able to settle their dispute. So again, what are the advantages? Well, again, the parties retain control because ultimately any settlement is one that they've reached themselves, right? They haven't ceded that ability to make a decision to a third party. And because the parties retain control, they're in active discussions, then it reduces the risk of damage to their ongoing business relationship. And if you recall, during negotiations, I said the parties could be deadlocked. Well, if you have a very experienced mediator, then they can help avoid those deadlocks or break those deadlocks. So a very experienced mediator will be able to see that the parties are deviating from aspects of discussions that will lead to settlement. They're starting to argue too much. So they will refocus their minds to the areas where both of them can benefit and try and streamline those discussions such that we'll reach a settled outcome. And again, there are time and cost savings because you need not involve counsel. You can, but it's relatively more efficient than proceeding with litigation or indeed arbitration. Well, what about the disadvantages? Well, you can't, like I say, the mediator cannot compel the production of documents. So if there is a specific issue in dispute and you say it turns on very important documents that are not before the mediator, there is no process to compel for the mediator to compel one of the parties to produce those documents, okay? And if there is a total breakdown in the relationships, then it might not be suitable. So some of you might be aware of a dispute between Epic Games and Apple, for instance. And the parties are so upset with each other, they have gone straight to litigation because there is now a total breakdown of their relationship. Each one thinks the other is fundamentally wrong in their approach and think that the only way to break that sort of deadlock between them is to go to litigation. And there is no guarantee that your dispute will be settled. So if you commit resources to the mediation process, there is no guarantee that a settlement will be achieved. But if in terms of initiating the mediation process, that's really the parties have to agree. And what you see in the screen before you is the model arbitration clause from the Abuja Chamber of Commerce, which I heavily commend, because if you incorporate this mediation clause, then essentially you are incorporating an entire framework that will assist the parties during the mediation process. So the parties, for instance, don't say, oh, what do we do at this stage? How do we get over this hurdle? So incorporating a framework to assist you in the resolution of your disputes through mediation, the ACCI framework is one that I commend. Conciliation. So what is conciliation? We often hear the difference, hear them used differently, right? Mediation or conciliation. Well, in actuality, conciliation is one where the mediator, or let me say the neutral, is more evaluative in their approach. So instead of the facilitative method where the facilitator simply enables discussions between the parties, the evaluative neutral will actively assist them to settle the dispute. So that mediator or the conciliator will make suggestions. Have you considered this? Have you considered this option or this cost if you continue with the disputes? So they take a more active role in trying to drive the parties to settle. And so as you can imagine, the advantages or disadvantages are very similar to that of mediation. But in addition, the parties may actually welcome that more proactive approach, particularly if they feel that neither of them are in a position to drive the discussions into settlement. Okay, so another means for another dispute resolution is something called a mini trial. A mini trial is also known as an executive tribunal. And what happens here is you have a representative from each party, right? And those representatives make their best case presentation to a tribunal. That tribunal is made up of senior executives from each of the disputing parties, but then it is chaired by an independent third party, independent of either party. And that independent chairman now acts as a mediator between the two senior executives. So let me just pause to ask Ebele if you could please mute your microphone, because it's I'm hearing some interference from your end. Thank you very much. Now, so what are the advantages? Well, it's a private and confidential, and it's made without prejudice. And I've already explained why these are advantages. But when it helps the parties understand each other. what are the commercial reasons and what are the commercial barriers to settlement, all right? When you have these executives that are making presentations, you might understand the viewpoint of the others. So you understand the other's commercial perspective. And it may lead to the avoidance of deadlocks, particularly when you have senior executives. These senior executives, their priority is to get the business moving because they are looking at their bottom line. So whatever steps they can take to avoid a deadlock and settle this dispute, they will be open to taking it. But let's look at some of the disadvantages, right? If one of the parties has a very favorable evaluation, then they may become more entrenched in their position. So if you have a mini trial and the outcome is that actually your position is valid, then you may say, well, then why do I want to compromise and settle for a less favorable position? I'm going to insist that I get it's either what the outcome of this mini trial decision is or nothing. And again, because it's a trial-like procedure, it's more adversarial, then it can polarize the parties again, okay? So these are some of the factors you may wish to consider. Okay, so let's have a look at early neutral evaluation. Now, early neutral evaluation, generally speaking, is non-binding, but the parties can actually agree to say the outcome will be binding on us contractually. And what happens here is that the parties will now appoint an independent person to evaluate the dispute and then, like I say, make a non-binding determination. And they will look at the facts, they will look at the evidence, they will look at the law relating to the issue in dispute, and they will give a non-binding, or if the parties agree, a binding evaluation. And why this is advantageous is because that expert, that evaluator, will identify and clarify what are the central issues in dispute, okay? And in doing so, they can give the parties a reality check to say, listen, I think it's more in our favor to settle this than in pursuing it, right? It sort of removes you from your polarized stance that is probably driven by ego to say, oh, looking at it objectively, it's not in our interest to continue down the path we're going. And it also draws a party's attention to the weaknesses in their case, something they may not have considered. Well, what about the disadvantages? Again, if one of the parties receives a good evaluation, then it could prevent settlement. They'll say, well, why should I compromise for something less? Okay. And in that sense, it can weaken your negotiating position. If the early neutral evaluation is that your case is not as strong as you originally think, then when you go to the negotiation table, you're in a weaker position theoretically. And it may not be suitable for where this dispute turns on facts, because again, you're evaluating law, you're evaluating evidence. So if it's simply a fact dispute, then this might not be the best option for you. But again, it's to weigh what the relative advantages and disadvantages are and to make an informed decision. So another one is expert determination. And expert determination is one that is used for very technical disputes. And Amala did sort of draw our attention to the nature of patents, right? The nature of industrial designs, the nature of trade secrets. Some of these are very technical in their nature. So if you have a very formulaic patent that involves lots of formulas or a very formulaic trade secret, then these are very technical issues. So you might want to submit it to expert determination because that expert's decision is contractually binding on the party. So as you're seeing, as we're going down the spectrum, you have decisions that are non-binding. Now we're starting to enter the realm where a third-party decision is binding on the parties. Okay, so what are the advantages? You have your time and cost efficiencies. And if you cast your mind back to that graph I showed earlier in the presentation, that's the two most important drivers of the party's choice of a dispute resolution process. They want it to be time and cost efficient because they need the product moving. And record again, it has a very short market life cycle. And because you've submitted it to an expert, then you have confidence that that expert's determination will yield a quality outcome. And again, that is another driver of the party's determination in making a choice. And the expert will make a thorough and comprehensive examination of the issue. So again, that now contributes to the party's confidence in the process. Well, what about the disadvantages? Again, it's for technical dispute. So if there are extensive facts in dispute, then this may not be the most appropriate means to resolve it. Likewise, the law is not as developed for expert determination as it is for, say, arbitration and mediation. So if you come to a stage where you don't quite know, well, how do we enforce the expert's determination, or what do we do if there is a stalemate in the proceedings? You can't, or not to an extent as mediation or arbitration, look to the law for guidance. So you need to ensure that there is a framework, a supportive framework that will assist you before choosing this process. And again, the expert's decision, because it's essentially contractual, you can't really enforce it if it comes to that without further court action or arbitration proceedings. So it will give you rise to another cause of action, but to enforce it in the event that one party doesn't accept the decision, you need to now bring other proceedings, and those proceedings will now bring other time and cost inefficiencies. So really you want to ensure that if I go down this route, it's one that both parties will accept. So now we come to arbitration. And arbitration, as we're all aware, it's an alternative to litigation, and essentially it's a private forum in which an independent arbitrator makes an award, and he or she makes that award in a judicial fashion, right? So they hear evidence, they hear factual arguments, they hear legal arguments, and they will make a binding decision on the parties. And that decision is it's limited in the sense that you cannot appeal the substantive correctness depending on the law. You cannot appeal the substantive correctness of that decision. Was the arbitrator's decision right or wrong in law? Generally speaking, you can't appeal on that ground. You have very limited grounds to challenge it. And those grounds focus really on due process concerns. Did each party have an equal or a full opportunity to present their case? Was each party able to enter an arbitration agreement in the first place? Does the arbitration award violate public policy? So those are some of the grounds, and we can explore those further in the Q&A session. And again, an arbitration clause I would commend is the one offered by the Abuja Chamber of Commerce. Generally speaking, I much prefer institutional to ad hoc arbitration, because from experience, I find that the institutional arbitration framework gives greater transparency and certainty, particularly when it comes to costs. So, for instance, the way the ACCI determines the arbitrator's fees will depend either on the amount in dispute. So if I have a 100 million naira dispute, I can tell immediately what the administrative costs would be if I choose the Abuja Chamber, and what the tribunal fees will be. Or it tells the arbitrators to say, okay, if you're not doing it ad valorem, then you base it on hourly or daily rates. But again, it tells you what those rates are. So there's a lot of transparency, and it speaks to one of the party's main concerns, costs. And I speak under the control of Chidimma and Aisha, who are on the call, but I also believe the ACCI rule sets a time limit for publication of the award. So again, it then speaks to this time efficiency that the parties are after. So I've mentioned some of the relative advantages and disadvantages of arbitration. I won't sort of highlight each of these bullet points, but in terms of the advantages, you can narrow it down into what I like to call the 4 E's. So the 4 E's, E for echo. So the first is efficiency, right? So arbitration is perceived as being more efficient in terms of costs than litigation is. The second is expertise, in the sense that the parties appoint an expert tribunal. So depending on the nature of the dispute, they will appoint a tribunal that has expertise in that subject matter to determine it. The third is equality. The parties have equal arms in terms of determining the arbitral procedure. And in fact, arbitration laws require the tribunal to give the parties full equality in terms of presenting their case. So if you cast your mind back to when I was discussing negotiation, I said a weaker party may feel disadvantaged. Well, to some extent in arbitration, you put them on an equal footing. So that's another advantage. And then the fourth E is enforceability. Enforceability in the sense that because of a convention known as the New York Convention, if I have an arbitration award from a convention country, I can go and enforce it with relative ease in over 150 odd other countries that are also signatories to the New York Convention. Now, if you juxtapose that with the position with a court judgment, it's less clear as to how you can go and enforce in other jurisdictions. Well, there are also disadvantages which are being displayed on the screen. You lose the flexibility of the processes like mediation or negotiation. Like I say, the arbitrator's decision is not subject to a substantive appeal. So in the rare situations where the tribunal really gets it wrong, and it can happen, then you have a very limited opportunity to review that decision. And in some jurisdictions, there could be substantial delays, not only in terms of getting an award, but in terms of enforcing it. So these are considerations you need to look at. So just as a review, what you can see here is the spectrum, right? This dispute resolution spectrum to determine which one is most appropriate for you. So it depends really on what you want and what the nature of your dispute is. So you, at one end of the spectrum, you have the very informal processes where the parties have full control, negotiation, mediation, early neutral evaluation. And it starts to go down the other end where it's very structured, very adversarial, and you cede control to a third party. But essentially, you need to see what are my priorities in choosing a dispute resolution process and which option will best suit my dispute. So in the interest of time, I will stop there and hand back over to Chidimma, and I welcome any questions you might have in the Q&A. Thank you very much indeed.
Thank you so much, Isaiah, for this insightful and wonderful presentation on the dispute resolution aspect of this webinar. You already know that you spoke on different mechanisms for resolution of dispute. You touched on the things, relevant things to consider before choosing a method for resolving intellectual property disputes. Now we are going to have the participants make their comments or ask questions to the two speakers where necessary. We have 15 minutes for this before we round up. So if you have a question, you could either notify me by raising your hand on the chat, dropping a comment on the chat button, or raising your hand, and I can unmute you to ask a question. Thank you.
Can you hear me?
Yes, I can. Amala, you already
Yes,
have a
I think I was a comment. Yes, I think there was a comment by Let me get Osu, yes. For myself and Mr. Isaiah, I don't know whether you want to go first or should I?
I'm happy for you to take the first bite. I haven't read the comments, so while you're responding, I can read the comments.
Okay,
and make
all right. Thank you. Okay, so okay, about some questions, and after said I had hoped that you would have touched on a few critical issues arising from long example under the trademarks. Do registered service marks confer any exclusive legal rights on brand owners, proprietors that are enforceable at law, bearing in mind the definition of trademarks under the Trademarks Act? I think that's the first part of the question. Okay, I think a quick response to that is this. I didn't want to touch that, so I also for the time which you recognize, but secondly, because I'm mindful of the fact that we have not just lawyers, but also other persons here. But the fact remains that our Trademarks Act, essentially our IP laws, are a key to this. And that's why I'm happy that we have this webinar by Abuja Chamber of Commerce Dispute Resolution Center, which is also a forum for us to bring to bear some of the deficiencies we have. Like as I had mentioned, the dispute resolution mechanism, but this dispute resolution mechanism has to be in part with the law. You know, he has done a beautiful job, and also looking at the various rules that the Abuja Chamber of Commerce, which is really fantastic, has. But like I said, you have to also match it in tandem with what we have currently. Sadly, and I'm also happy to see that we have the former Attorney General of the Federation, Mr. Adeyemi, here with us. So maybe these are persons that can also help add voice to some of these things. The Trademarks Act that we have now is a 1965 legislation that was essentially copied from the 1938 UK Act. In England, I think they've changed the law in 1994. So we're using a law that was made in England in 1938 and enacted in Nigeria in 1965, which is a long time. So the law is not in tune with modern realities. And to your question, the reality from a legal perspective, although we IP practitioners, I think I would say that we observe it in breach, is that the definition of that we have under the Trademarks Act does not recognize services. We don't have provision for service mark. There was something that was done in, I think in 2007 by the Minister of Trade and Investment, which was to expand the classification of goods to services, which is what the Trademarks Registry is using now. But the reality is that, my opinion, I might be wrong, but I think there's even a judicial decision on it by Justice Idris, who is now at the Court of Appeal, that our law does not recognize service mark. So this is one of the areas that we would expect more, because, for instance, if somebody now, just as I has beautifully stated, brought up, there's a dispute, there's an SP dispute, and I use an example, figuratively, Uber, and a rider has a dispute, and they decide to use the very fantastic provisions, the very fantastic rules that the Abuja Chambers of Commerce Dispute Resolution Center has. You find that, and it has to do with service mark, you find out that under our law, you don't have any provision for that. And that makes a total nonsense of the entire thing. So there is a need, an urgent need to amend our Trademarks Act very urgently, for it to be in tune with modern realities. Now, the second one is, I think the second question had to do with validity of priority registration. So for some of us who so the idea is that when you register a trademark, especially for foreign brands, and you go to the Abuja Chambers of Commerce for help in terms of assistance, because I know they provide expert assistance on investments in the Abuja Chamber of Commerce and do that. the way the law should work is such that if you have a trademark registration, let's say you are coming in from Russia, for instance, that you would, if you have a trademark registration and it's a convention country, you should be able to claim priority such that your registration there would count. However, in Nigeria also, there is supposed to be, I think it should be section 47. I'm not very sure, but it should be section 47. That has to do with that. There is an executive order, or as law states, a proclamation by the president that would allow that to happen. That has not happened. There's no such executive order. So as it stands now, you can't do priority. You can't claim priority when you are doing trademark registration in Nigeria legally. Some people do it, but for me, it doesn't have, that's my personal opinion. It doesn't have any validity because there's no legal backing for it. So I think that calls for some food for thought for some of us as IP practitioners and practitioners generally, because insofar as our law does not remain in tune with modern realities, then the IP space, which is huge, Isaiah has shown us some of the valuable companies that have valuable IP assets, then you would not be able to harness as a country the huge potential in IP. And you won't also be able to resolve some of those disputes optimally, whether by way of LDR, which is provided by ACCI Dispute Resolution Center, or even by the conventional court system. So maybe let me allow Mr. Isaiah while I look at the other questions.
Oh, no, thank you very much. So just to speak to Mr. Okoyen's comment concerning that we need to have a discussion regarding the Supreme Court decisions on copyright issues in the last 24 months. I agree with you entirely. It's important for two reasons. So the first, Amala has already touched on it. The first is that such a discussion will bring to the fore any areas in which the law is lacking and requires reform. Because like Amala says, if we do not have a legislative framework that is fit for purpose, then it stifles the development of industry within Nigeria in terms of new businesses exploiting their IP rights properly or attracting investors to this jurisdiction. So the one that just came to mind as Amala was talking, and I don't know the motivating reasons for their choice, but was Twitter's choice of Ghana as their HQ in Africa. So, I mean, presumably, if we had a more welcoming legislative framework, maybe that decision could have been different. So we do have to have a conversation that will highlight some of the shortcomings in the legislative framework, or indeed to showcase the friendly decisions made by our courts that show that this is a jurisdiction that welcomes innovation. So the second reason is more connected with arbitration, right? Particularly for international contracts. So in international contracts, there's always this conversation as to what choice of law should govern the contract and what seat should be the seat of an arbitration, right? So again, the reason that foreign companies choose to have a foreign governing law or a foreign arbitral seat is this mistrust of the Nigerian system. And again, if we are transparent as to how the courts make these decisions, then we are instilling confidence in foreign and domestic participants that actually we can submit these disputes to our courts and we will get a just decision. Likewise, for the arbitral seat, they can show that, well, the courts are in a position to support this dispute resolution process. So in very many ways, having a conversation as to how the courts hear and determine these disputes is very important for this jurisdiction. So I realize that was more of a comment from Otu than a question, but I agree with you entirely. So I'll hand back over to Chidimma if there's another question, or to Amala if you wanted to make a further point.
Thank you, Isaiah and Amala, for the answers to this question. I think we'll just take one more question for Amala and one more for Isaiah before we round up because of time. I can see a question from Mr. Franklin Mark. Amala, would you be able to take that?
Okay. I think he has two. One is the extent, of music publishing under copyright recognized in Nigeria. Like I mentioned, I will just do an overview. It's recognized, right? Like I said, copyright covers the protection of one's ideas and, so to speak, creativity. So it's covered under the Copyright Act. Just on the, let me just make that broad comment. Like I mentioned, there is no registration process. So there's a case going on now between, I think the name is Casey, and then a gospel artist on that's presently ongoing. That I don't want to comment on it because that will also show it's a case currently going on at the federal court, but that will also show the level of protection. But copyright protects music in Nigeria. The second one is recognition of IP assets as bankable assets under CAMA. Yes, it's currently the current CAMA recognizes it as a form of security that can be used as a means of obtaining credit, and that can be registered. You're supposed to register these mortgages as CSC. So there's a provision under CAMA now for it, expressly recognizing it as an asset that can be used for obtaining securities.
I think Amala's network has been interrupted. I'm not sure I can see any more questions from the participants.
I see a question from Abdulkarim Muhammad. Oh, Amala's back. Let me just check if he has finished making his intervention before I answer that question.
Okay.
So Amala, I just wanted to check that you had finished your intervention. Okay, I'm not sure. Let me go ahead. So Mohammed asks.
Sorry, I didn't get that.
Oh, it's okay. I was just checking that you had finished your intervention before I started making mine.
Yes.
Okay, many thanks indeed. So Mohammed asks whether ADR can be used to resolve all issues where the matter has been referred to a state agency before contemplation of ADR. Mohammed, like any legal question or like any answer a lawyer would give, it depends, right? It depends on what the nature of that dispute is. So if we take tax as an example, where many of you will be aware, with decisions from the Court of Appeal, 3 decisions specifically that touch on the arbitrability of tax disputes. And where the Court of Appeal finally landed was to draw a distinction between contractual disputes, which are arbitrable, and in that case, tax disputes, which it viewed as disputes concerning the application of tax legislation, specifically if the dispute is of a nature that requires the tribe, that will entail the tribunal usurping the functions of the tax administrator, then that dispute is not arbitrable under Nigerian law. So you can look at a similar issue with IP, because IP also falls under that section 251 band in the Constitution. So if the dispute is a legal one that requires the interpretation or application of IP legislation, then it might not be suitable for certain dispute resolution processes. And we could have the same issue to say, well, if the tribunal is going to usurp the function of a regulator, then it might be interpreted as non-arbitrable. So we did an arbitration recently that involved a distribution agreement where this issue came up specifically. And we were very careful to say that we realize that the parties have submitted this issue, but this strikes us as one that is susceptible to damaging this award, because it would involve our taking decisions that the regulator should take. So we kept our hands off that. Now, if the dispute is one that involves a lot of factual dispute, not necessarily legal disputes, then yes, notwithstanding the reference to the regulator, then you can solve it through ADR. And again, I'll give tax disputes as an example. So we see, for instance, disputes between tax regulators and taxpayers, where an investigation is going on, but is ultimately resolved through negotiation. Because in disputes of those nature, the parties have the ability to compromise their respective positions, because legal issues are not in dispute. And don't forget, you can't contract out of law, right? So there is no yes or no answer to that question. It will depend largely on the nature of the dispute. So I hope that clarifies your question. And again, I'll hand back to Chidimma.
Thank you, Mr. Isaiah. At this juncture, I think we have neared the end of this webinar. Of course, this conversation on intellectual property dispute resolution will be an ongoing one. It's not going to end today. We keep talking about it. The next time we are going to have a discussion on this, we're going to be inviting the relevant stakeholders to a workshop on intellectual property dispute resolution next year. And we are enjoying all the participants and the panelists to grace us with your presence once again. On behalf of the Abuja Chamber of Commerce Dispute Resolution Center, I want to especially thank the panelists, Isaiah and Amala, for the wonderful, impactful speaking for myself, and I'm sure most of the participants agree based on the comments on the chat. Presentation in this topic, even with the short notices, they were able to be here to give this presentation. Thank you. And for the participants that have been here for over 1 hour listening and taking notes, thank you so much for gracing us with your presence. We at the Dispute Resolution Center of Abuja Chamber of Commerce, what we basically do, we are a an institution with the mandate to resolve disputes using alternative means. And we welcome everyone to our center for resolution of disputes. Thank you so much, and see you next time in our events. Bye.
Thank you very much for inviting us again. Have a nice day.
Thank you for
Bye-bye.
having us. Thank you. And thank you, Isaiah. Thank you very much.
Some people asked whether we could send the record and the presentation of the panelists. Yes, for those that have registered for this webinar, you're going to receive this Zoom recording and the presentations from the panelists shortly to your emails. Thank you.